Ashley, would you call the roll, please?
Absolutely. Representative Allred?
Here.
Representative Andrew?
Here.
Representative Berger?
Here.
Representative Brown?
Here.
Representative Clausen?
Here.
Representative Lawley?
She's excused.
Representative Obermuller?
Here.
Representative Provenza? Here. Chairman Northrup?
Here.
You
See
have-
Representative Lawley just walking in. So
Perfect. You have a quorum.
very good. Thank you. Okay, so a little groundbreaking, make sure everybody's on the same wavelength. No cheering, no clapping, no anything else. We treat each other like adults. And if not, I see, no, my bouncer's here, so we're good. Okay. We will start this meeting and we have Senate File 9. Does anybody like to take that on? Nope. Nobody wants to take that on. Dandy. So, hang on. This is parental rights and education. We took this bill on at the interim. If you remember, we worked on it at the last day in the Capitol, down on 110. Okay, so as you look at page 1, the Senate did not make any changes. I'm going to go through and talk about the changes that are in the bill. Hi, Darcy. And then we'll work the bill if anybody wants to go through the whole thing again. So on page 2, line 9, 10, and 11 have some stricken language. On line 9, they struck out and the, and on line 10, page 2, struck out school's ability to provide a safe and supportive learning environment for the student on line 11. That was stricken out. Let's go down some more, and I thought I had one more note in here. Oh, they did. It's added into the blue copy.
Page 4.
Yep.
lines 3 through 6.
Page 4, lines 3 through 6 added in some new language. Everybody get a chance to find it? Nothing in this section shall be construed as preventing school district personnel from rendering first aid to a student or summoning emergency responders in case of a sudden need. All right. So committee, you've had a chance to read the bill. You've had a chance to read the blue copy. What's your thoughts on the bill?
Public comment.
Oh, we better take public comment, yes. Thing, just jumped right into it.
Department first.
Yep. So we'll have the department go first on public comment, and then any other elected officials, and then we'll move to the public. The department has no comment. Any other elected officials? Then we'll move to the public. Anybody in public like to comment on Senate File 9? Please come up, fill the chairs, and we're doing a 3-minute time just because it looks like we have a crowd, and everybody'd like to talk, so. Who's timing? You are?
Yeah, I
Good,
can
you
do
time
it.
it.
Oops, I forgot my phone, I'll watch yours.
Go ahead and start. Good. Any one of you?
Mr. Chairman, Bill Winnie, Sublette County. In common parlance, we often confuse rights and authorities. And I would remark that parents have rights in this regard as this legislation contemplates. But no school district, no board, no superintendent, no principal, no vice principal, no teacher, no staff member have anything but authorities, and those authorities are devolved from the legislature. And that's where we get into a confusion of rights and authorities and so on. Parents have rights with regards to their children. I had the experience, I served on active duty 2 years on the island of Guam. And at the time I reported there, the Department of Defense had set up an arrangement whereby instead of establishing a DoD school system, they gave a certain amount of money to the Guam public school system. My wife is a professional career educator, And as we observed our children, 3 boys, through the first year, we concluded that the school system was not adequate. The result of that was our younger 2 boys, we pulled out and she homeschooled them. As a career educator, she had often said she would never homeschool. That was the best choice she had at the time. Our older boy, we're not of the Catholic tradition, but we ended up putting our older boy in a Catholic parochial school. When I departed the island, I wrote a letter up to the chain of command outlining my experience. And the result of that was the Department of Defense came in and established a DoD school system and withdrew from the arrangement they had previously had. The upshot of all of this is what I said at the very beginning. School districts have authorities that devolve from you, the legislature, not rights. And parents have the rights. Our Constitution established schools and the Superintendent of Public Instruction specifically contemplating that the education process would be more efficient, more knowledgeable, more educated than if they did it at home. That didn't grant the school system authority to do things. We had a case, as I understand it, I've heard in testimony, I believe it was in Sweetwater County, where a student was given a cell phone and told not to
That's
speak.
time. Go ahead and finish up. Give you
Okay.
a closing remark.
I'm wrapping up, sir. And told not to communicate with parents. That doesn't make sense. Subject to your questions, thank you.
Thank you, Mr. Winnie. Any questions for Mr. Winnie? Thank you, sir. Go ahead and state your name.
Good afternoon, Chairman Northrup and representatives. Richard Lennox, retired teacher, and we have a small business here in Cheyenne. I want to first apologize for my attire. I just kind of ran over from work. When I taught, to the chagrin of other teachers, I used to tell them, I don't like to send my students up to the office. If there's a problem, if there's disruption in class, disrespect, I always wanted to take care of it myself. Because what I noticed was when students went to the office and they calmed down from the incident and they talked with the vice principal or the counselor, they built that relationship in those moments after they kind of calmed down. And I used to say, I don't want to give up that relationship as a teacher. I want to work with them through this problem. I want to be there so we can move forward as a team. I wanted to have that communication. What I'm seeing with this bill and other legislation is community members are overstepping the teacher, the district, the school board, and they're coming to you and they're coming to the state to fix the problem. But they're bypassing those very people that they want to have a relationship with. And so whether you pass this bill or other legislation or not, they may feel good about that, but it doesn't build the relationship and the trust in those communities that those parents are really after. They're looking to have that relationship with the school and have that communication with the teachers and the counselors. But when we bypass that, it's just not going to happen because the trust isn't there. And that's my testimony. Thank you.
Thank you, sir. Any questions from the committee? Thank you for testifying. We appreciate it.
Thank you.
Go ahead, please.
Hi, my name is Janet Farmer. I work as a school nurse here in Cheyenne, although I'm not representing my district. I am also a past president of the Wyoming School Nurses Association, and I am currently the Wyoming director to the National Association of School Nurses. There's 2 or 3 things in this bill that are concerning. I'm just going to focus on a couple since we're short on time. The first one is page 4, paragraph C. It talks about health screenings. The Wyoming Department of Education has already developed protocols. They're already in place for vision and hearing screening. And that's what school nurses across the state use to determine what grades they screen and what that screening, those screenings look like. The IDEA law, the federal law, does use child find. So screenings are not necessarily mandated for special ed screening, but especially hearing screening is a very important part of that detection piece, because the only way to detect a hearing deficiency is through a mass screening or through a screening. And I would say the same as might be true for vision as well. So we just need some clarification on what the desire of that paragraph is. Do we just need to tighten the language in districts? Currently, our district does have in our student handbook information on the screenings, and parents do check during our online registration that they consent to those screenings. The biggest concern that I'm finding in my peers is on page 3. It would be paragraph B, and it discusses making a list available to parents and guardians of any healthcare services offered or provided. There's several concerns we have with that. And I'll just tell you a quick story. My current job with this district is administrative, so I'm not in a school. I spent my first 10 years in a school dealing with students. But because of an emergency with a school nurse last week, she had to leave. There wasn't a sub available, so I covered her school. It was an awakening, even though I used to do it. In just over 70 minutes, 32 students came through that office. And just as a point of reference, if you go to your doctor or your healthcare provider, they probably see 3 to 4 patients per hour. So in that short time frame, I had seen 32 children. The whole day for that school was closer to 80, and that's actually pretty normal in a school nurse's office. So that brings up a lot of issues. I felt like in that 70 minutes, I was lucky to keep my head above water.
30 seconds left.
Okay, sorry. So some things to think about in this list. When you make a list, there will always be something that's left off. So a student comes in, we have permission to give them medicine for a headache, but they come in because they're bleeding, but we don't have permission for that from the parent. So can we do that? Or maybe they come in because they have a stomach ache. It's not an urgent need. So I would stand for any questions.
Questions for the good lady. Go ahead. Representative Brown.
Thank you, Mr. Chairman. So the Senate added some language here that I'm not sure really makes me feel much better, because I share your concerns, but it says nothing in this section shall be construed as preventing school district personnel from rendering first aid to a student or summoning emergency responders in case of sudden need. What is the possibility of a school nurse, I guess, what liabilities are available to school nurses in the event they determine that it's first aid versus what the parent determines as first aid? What liabilities does a school nurse open themselves up to?
Please go ahead, ma'am.
Chairman Northrop, Representative Brown, there's an unlimited amount of liability. If I were working in a school, I had an urgent need come in, I work under a nursing license, and that's a unique position to be in an education. My nursing license guides my practice. So if there's an urgent need, if there's an injury or a significant issue with a student, my first duty is to provide care. I'm not going to check to see if I have permission first, and so that puts me in a very significant liable situation.
Follow up?
Yep, please, Mr. Chairman, thank you. So here in Laramie County, you guys have the opportunity, if a student comes in, let's say has a broken nose or is bleeding from the nose. Not life-threatening, you can't imagine, but certainly gushing out blood, you have a pretty serious situation. is that something that you would consider immediate or first aid versus I need to check my computer to determine whether or not your mom and dad has allowed me to render critical care to you?
Go ahead, please.
Chairman Northrop, Representative Brown, in my professional opinion, that would be a first aid and emergent need. You need to stop the bleeding. So I'm not going to check permission first. With each one of these issues, with the way that this is written, we would need to have a very long list of medical conditions. And so each student would have a very long list, and each nurse would have to check each student every time they came in for every permission. So I don't see it as being realistic in that fashion. Certainly, there might be the option to develop umbrella terms like wound care or acute care or illness, something like that. But I am not sure what that would look like either.
Further questions from the committee? So I have one. So when I was in grade school, we were playing football and got tackled and of course broke a collarbone, passed me out, laying out there in the middle of the floor or the grass. And when I woke up, I had a teacher over me and a nurse saying, "Are you all right? Are you all right?" If that happened under the way this law is written now, statute, how would you handle that? I mean, first off, you don't know if you have permission to even give me aid. You don't have permission to do much. So, I mean, I know what ethics mean and how I would handle it, but please answer the question if you would, please.
Chairman Northrop, I would say that any nurse or any medical professional is going to provide the treatment before they check the permission. But that's not what this says. It says that parents can withdraw that or decline that consent. And so then that nurse is opened up to liable action because they provided a treatment that they didn't have permission for, even though in your case, I would say that that's maybe not an emergency, but certainly an urgent need.
Thank you. That's what I was heading for, was that liability factor. Go ahead, Representative Berger.
Thanks, Mr. Chairman. Thanks for being here. Coaches, we go through care and prevention training. You know, you heard on the football field or wherever, do you see that as well for coaches? I mean, it's kind of like, well, I don't know, how do you feel about that?
Go ahead, ma'am.
Chairman Northrop, Representative Berger, I would say it absolutely would apply to coaches because the way the language is written is it's any health services.
Okay.
So any first aid or treatment provided by a coach or an athletic trainer would be affected.
Further questions? Go ahead, Representative Brown.
Ms. Farmer, just out of curiosity, so your first line of supervision as a school nurse is to the principal, is that correct? And I've got a couple with your,
Yep, please, we'll have an indulgence. Go ahead.
Chairman Northrop, Representative Brown, yes. School nurses in Wyoming are generally supervised, their immediate supervisors are principal.
Proceed.
so then secondarily, if, let's take the scenario of a kid who breaks his nose or has a bloody nose, comes in and the nurse wipes the nose, looks at it, says, "You're fine, go back to class." Everything, kid goes back to class. Mom and dad come back in and they say, "You rendered aid. I never opted in for that." And they file a complaint. As it's written here, they have to first go through the process of filing a complaint with the school district. Could they also then go for the liability factor against the nursing practice with the Board of Nursing? We didn't even touch on that with something like that. And that's something that, as you were talking about, your first duty is to take care. It then concerns me about the Board of Nursing having oversight of something that we didn't even contemplate in this during the interim.
And would you please answer that question and answer about the liability of losing your license?
Chairman Northrop, Representative Brown, I would say it's certainly a possibility. The Board of Nursing's duty is to protect patients. Board of Nursing's duty is not to protect nurses. So certainly it's the public's prerogative to file a complaint. And they would go through that process to determine if the complaint is legitimate or if the nurse acted outside their scope of practice. So with that being said, I would say certainly I could lose my license, yes.
Anybody else on the committee have any more questions? Thank you, Ms. Farmer. Please go ahead.
Mr. Chairman and members of the committee, I'm Lindsay Adam from Pinedale, Sublette County, Wyoming, also with the Level Up Teacher Group. I was initially neither for nor against this bill. I think in a lot of ways it represents reporting that most districts are doing already as part of their due diligence of just keeping parents informed. Based on the last person's testimony, I would say there's some wording here and still that has ramifications in terms of the physical aid that we can provide students that I don't think was fully thought out initially, particularly on page 2 in item C, where it says, before administering a well-being questionnaire or health screening to a student or group of students. My understanding with the initial intention of this bill was much more, there was more concern about what might be said to students and between counselors and teachers and students behind closed doors as with regard to their mental health and their emotional state. And throwing in phrases like, or health screening, then brings up the whole bag of worms of vision screenings and ear screenings, not ear screenings, but you know what I mean. So it really just brings me back to some of this language is much too broad and doesn't really align with what the initial intent of the bill was. You could easily change health screening to emotional screening, but then that still brings you to some concerns that the previous speaker just mentioned with paragraph B. So I would say as this bill's written right now, my vote would be against it, and I ask you to do the same. And with that, I stand and yield for questions.
Questions from Lindsay? Anybody? Thank you very much. Please state your name.
Good afternoon, Chairman Northup. I'm Michaela Bradshaw. I'm a principal here in Cheyenne, Wyoming, also part of the WDE Level Up group. I'm not here representing my school or my district today, but one thing I'd like you to keep in mind as you are dissecting this bill, many times in my world, with what I do, I am in a middle school setting. We have students that come in and we don't know under what symptoms they are showing physically, if they are under the influence or not. So one situation that I get a lot are parents being upset or not upset about simply taking vitals of a student. If the nurse is there to take vitals just because of their physical symptoms may or may not be showing, if they are under the influence, some students may admit they've used a vape, but they aren't sure if it's a THC pen or not. And if it's a THC pen, what else could be in there? And that would also determine if the nurse makes it necessary to provide Narcan or not. So I'd really like you to keep that in mind when that truly is a life or death situation. If a parent says, no, you will not take vitals of my child because they are nervous of what their own consequences may be, as a parent, it could be the life of a child at stake. I stand for any questions.
Well, good point, Michaela. So anybody else have a question?
I will have one, but
It's coming, yeah. There's a lot of thinking going on.
Yep.
We'll get to that point and we'll ask for your opinion. Thank you.
Thank you, Chairman Northrop, representatives. It's an honor to speak before you again. My name is Patricia McCoy, and I have been a resident of Laramie County right here in Cheyenne since 2007. I'm the mother of 4 children, 3 of whom have graduated from the high school here in Cheyenne, 1 of whom is still there. I can tell you that as a parent, my rights have been violated by the high school that my children go to on several occasions since my oldest was first enrolled there in 2014. My youngest still being there now, let me tell you, really has me considering homeschooling him the last 2 years of his 4 years at that school after everything we've gone through so far. Able parents, not schools, should be in the driver's seat regarding a child's mental health and well-being. It's vital that parents are a part of these conversations. I've seen firsthand what can happen when teachers and coaches take it upon themselves to influence an impressionable 14-year-old girl. That girl was my daughter. She was influenced for 2 years while her father and I tried to fight against it. We were made to be the enemy. We were ostracized. She was told not to speak to us. She was given a binder and told to hide it from us. So that stunted some of her growth for the entire time that she had that we didn't know about. My biggest question here is, it really doesn't matter about beliefs or politics, things like that, but we almost lost our daughter completely. Not here anymore, tried to take her life because of the mental health issues that were caused by the influencing of others upon her. She's doing much better now, I'm happy to say, now that she's no longer around that situation, and we have been able to get her out of it, but she's one of many. What about the ones that don't get saved? What about the ones who don't get pulled out? What about those kids? What about the parents? Where are their rights? My rights were violated. Where was my recourse? What steps did I have to go through? I went to the principal, I went to the coaches, I went to the school district, I went to the school board. I did everything I was supposed to as a parent, and I had every door shut in my face. So yes, I do sit before you now asking you to jump over them, because clearly going to them did not do much of anything for 2 years. Now I sit here. Parents know their children best, not the schools, the districts, the teachers. We already have one district in our state that has policies that make it okay to hide a child's identity and gender from their parent. And it's not the one that allowed this to happen to my daughter. So let's be clear on that. The one that doesn't have the policy allowing this behavior allowed it to happen anyway. I went through the steps that your Senate and House and Congress gave us as a parent. These are my
30
steps to go
seconds.
through. I did that. Now, as a parent and with other parents, I'm begging you, step in, step up, and help us protect our kids. I'll take any questions. Thank you.
Thank you.
Go ahead, Representative Brown.
Ms. McCoy, I'm curious on your thoughts on the discussion that we have, especially on page 3 here, where it's making sure that we have available to parents and guardians any healthcare services offered or provided at the school, and provide the option for the parent or guardian to withhold consent. So if there was something such as chest auscultation, would you know what that is as the average parent?
Nope, I
Okay.
would not.
Through the chair, please.
Oh, sorry, I did it again. My apologies, Chairman, Representative Brown. No, I would not know what that was and didn't until I found it in my daughter's room.
And then, Mr. Chairman,
Please
follow
go
up on
ahead.
that. So an exhaustive list that was discussed with us by the school nurses. Out of that, do you feel, as a parent, you would feel qualified to opt in / opt out, how we have it currently written, as a parent to opt out of the services that are performed in the school nurse's office? Or do you feel that the nurse is more qualified to render that care without having to seek your permission?
Go ahead, Ms. McCoy.
Chairman Northrup, Representative Brown. Actually, I do opt out of some of those things. I do go through the entire list that they give us at registration every year. And there are some things that I do opt out of, certain medications and things like that that they have listed. One, to deter my kid from going to the nurse's office and skipping class, let's be honest, right? But also, I go more detailed than that in mine. I do the opt-out form every year, and not only do I do the opt-out form, I also email everything to my school principals, and it still doesn't get followed, so I'm not quite sure where to go from there.
I get it. Good, thank you.
Further questions for Ms. McCoy? Go ahead, Representative Lawley.
Thank you, Mr. Chairman. Ms. McCoy, if I heard you correctly, your school district already does what this statute's talking about, at least in terms of notice and opting out. Is that correct?
Chairman Northrup, Representative Lawley, yes, that is correct. So when I register my son for school, it gives me the list that the nurses are referencing for the medications and the services that I do want them to provide or not provide, including first aid. And yes, I think there's a huge difference between first aid and just general care. So for me, yes, I read through everything that they have there. It's not very confusing. It's Tylenol, ibuprofen, cough drops, like everything is on there. The chest things are not on there. It's not on the list or I would have opted out of it.
I understand. Thank you.
Anybody else? Questions for Ms. McCoy? Thank you.
Just to follow up.
Oh, go ahead, Representative Brown.
Thank you. Ms. McCoy, you just stated something, as you finished it, it kind of fired a synapse in my brain. Until it was brought up, you wouldn't have done it, but you would have opted out of it, right? And so as you're doing that, that's what I'm trying to find out is if we have such an exhaustive list that we're going to send a packet of potential medical things that could happen, and then that nurse is required at that point, if your child comes in, is required to go look up your student prior to administering anything to determine whether or not they can or cannot treat that particular situation for every single student. How do you feel about that? I guess would be the easiest way for me to ask that.
Go ahead, Ms. McCoy.
Thank you, Chairman Northrup, Representative Brown. I do understand that can be daunting to a school nurse. I also understand that school nurses no longer know how to flush eyes if your kid gets something in their eye, which I did opt in for, just to be clear. I sent my son who has eye issues to get eye drops. It's on his opt-in in those checks that they can give him eye drops and that they can flush his eyes. I also sent in a letter explaining he would be needing this to be done after his eye procedure. And I was told by my son, can you please come pick me up? The nurse cannot flush my eye. I said, what do you mean she can't flush your eye? I'm sorry, I was a little taken aback by the response. And he said, she told me she cannot flush my eye for me. She gave me some drops and told me to go over the sink.
Thank you.
Further questions for Ms. McCoy? Thank you very much for coming.
Mr. Chairman, Boyd Brown, Wyoming School Boards Association. Just a couple things to think about for the committee as they're working through this. Schools have a lot of federal rights laws that they have to be aware of. They also have a lot of other state rights laws that they have to be aware of. I guess as we move through looking at this, I would caution the committee to get crosswise with some of those other laws because it would put the districts in a rough spot. We have everything from FERPA to the Parental Rights and Education Act. We have even the SIPA, or not SIPA. I'm trying to think of the medical one. HIPAA. There we go. Thank you for the help from behind. Yes. But I think there are a lot of things out there that we have to do. And feel like most of our districts try to do a great job of having a good relationship with parents and trying to do the best that they can there, knowing that there's going to be some issues every once in a while that are going to come up. But cautioning that we may get in between two different things as we move through, trying to work both sides of this. With that, I'll answer any questions.
Benza.
Thank you, Mr. Chairman. Mr. Brown, I'm not sure if you can answer this question, but I'm hoping that you can. We talked about the nursing licensure and concerns with the contradictions between this bill and the nursing license. I have concerns about counselors in schools. So if they are licensed as counselors, they also have a different licensing requirement and obligations that they have to meet. Do you know anything about what that looks like and potentially how that could contradict this bill? Or if there are any school counselors in the audience, I'd love to hear from you as well. Thank you.
Go ahead, Dr. Brown.
Mr. Chairman, Representative Provenza, I know just enough to be dangerous. I would say that there are issues of privacy that counselors have to deal with, and there are different levels of licensure for counseling. A lot of our school counselors are licensed as professional counselors as well. So I think when you look at that, there are different levels that you'd have to do with that. I do know that all counselors let students know that if there's an issue of safety to themselves or others, that it would not be confidential, but there are a lot of other things that would be considered confidential issues that they may work with their clients on. And that's very general.
Phone a friend here. Go ahead, Ms. Bradshaw, please.
Chairman Northrop, Representative Provenza, when it comes to counselors, social workers, and even now in our district, we currently have BCBAs. They can work within the school bounds. So if they have a private license, it cannot be utilized throughout the school time within those school walls. They use that knowledge that they have, which is good practice. If there is anything that should go into the private sector for that kiddo, we, in our district, I'm not sure how it is in others, but we have a parent sign off on a, it's an exchange of release of information with the private social worker that's outside of the district or counselor. So we can communicate with them in regards to what is best for that kiddo within the school setting versus what are they using and practicing with skills outside of the school setting.
Very good. Anybody else have a question besides me? Okay, so don't leave, because I was going to call on you. Please, Ms. Bradshaw and Boyd Brown, would you guys talk about if you had a student come into the nurse's office and that student was exhibiting a reaction like he had taken a drug of some kind and you were suspicioning there was drug use going on? I don't know how the district would handle it. I'm not sure how this, or school would handle it. Maybe it's middle school would be different from the district, and how your nursing staff would hold it or maintain it and keep it. Is it part of the, just let me know what happens. Thanks.
Definitely. Chairman Northrop, if a student would come down presenting any symptoms, typically what a teacher can see or smell is what would send a student to our office. So the dilated eyes, really slow speech, and or the aroma, if you will, that's a cause of concern. When a student comes down to our office with that, we immediately notify the nurse and we immediately call home. So those two are the first two things, making sure that is their immediate need. The nurse will check in on our kiddo. If need be, we'll ask for those vitals, because vitals are a better tell, especially in middle school when our kids are often tired or something else could be going on. Hour by hour, you never know. We want to get as much information as we can to make sure we are going to try to do what's best for the kiddo. So typically it's simultaneously I'm calling home while the nurse is checking on stats and getting those vitals for us, so we can use that information as we're on the phone with the parent.
Anybody else have a question? Go ahead, Representative Berger.
Thank you, Mr. Chairman, and
Bradshaw.
Ms. Bradshaw, thank you. Back to the release of information, and I mean, that's very common practice, especially with IEP students, and getting that release of information form signed. Do you think that's all districts are using that and making sure that that release of information is there so that they can talk
Go ahead, Ms. Bradshaw.
Thank you, Chairman
to
Northrop.
other entities? Sorry, yeah.
I sure hope it is. I don't know if I
Yeah.
could speak to that. A big part of that would also be when we're talking about DFS. We also, we do not, unless we know we have that exchange of information, there is very, very delicate information. And when you think of me as the principal, and I am in charge of that kiddo, right, for those 7.5 hours, and it is my decision if DFS is coming in to talk to those kids or not. That's a very, very delicate situation. So one, I would sure hope that even when it comes to DFS or the sheriff's department, whomever, that that is something that is available and readily to have signed before anything is going out.
Thank you. Anybody else have a question? Yes, no, maybe so?
Yeah, maybe.
Go ahead, Representative Provenza.
My brain was bouncing back and forth, so maybe you said this. So if DFS came to speak with a child under this, then would the parents have to be notified? And yeah, okay, thank you.
Thank you for clarifying that. Yep. Yep. All right. I think we're good with you guys unless you have a comment you'd like to make. Thank you.
Thank you.
Anybody else? Anybody else from the public like to comment? Anybody else? Please go ahead, Mr. Winters.
Thank you, Mr. Chairman, Committee. My name is Nathan Winters, President of the Wyoming Family Alliance. I just wanted to come up and say I appreciate all the hard work that's been done, both in the interim and in this session thus far, in favor of this legislation. And that's why it's been very positive, popular, all the way to through the process thus far, especially as it appears that this fosters and ensures that the relationship is maintained between a school and the parents and their child. And I also have to say I appreciate the amendment, I think, that clarifies, that came through from the Senate to ensure that many of the scenarios that have been described, bloody noses and such, that those are kind of taken care of at this point. Is simply a bill that ensures that parents are not cut out of the equation in regards to their children. And we support legislation that would ensure parents are notified of the health and welfare of their children in schools, so that that critical information is always a part of the relationship between the child and the parent. So with that, Mr. Chairman, I would stand for any questions. Thank you.
Thank you. Do you have any questions for Nathan? Mr. Winters? Thank you, sir.
Thank you.
Please state your name, sir.
Good afternoon, Chairman Northrop and members of the committee. My name is Steve Milia here in Cheyenne. As having been a professional educator back in the 80s in Nebraska and as a public health educator in Houston for several years, I did a lot of classroom teaching. And I always told my students, make sure you tell your parents what we talked about. Didn't make any difference what it was. Parents needed to be informed. As far as my forming a trust with my students, I thought that was very important, but I also thought it was very important to form a trust with my parents because we're all a team. I didn't want to separate my parents out from anything. And I like this legislation in that it, as Mr. Winters had said, that it does not cut the parents out. And I would assume that all of you or most of you have been or are parents. And if something was going on with your child, or even maybe your grandchild, would you want the school to withhold information from you saying, well, we don't trust you because we don't trust you, so we're not going to tell you this information? In my opinion, that is extremely wrong. And if one time I did say to one of my students, well, don't tell your parents about this. Well, I heard from a lot of parents because all the kids went home and said, hey, he told us not to tell you about this. And they told they all came back. I said, well, and I had no excuse. So that was the last time I ever did that. But I knew that the parents knew because the students told them. And I think that's very important. I do have one particular story. My niece up in Minnesota, she had a 16-year-old daughter, perfect health. We don't know what happened. We thought that maybe she had gotten the COVID shot. It's only speculation. She came home one day after school. She said, I'm tired. I got a little headache. She's going to go take a nap. And my niece said, okay, well, call you in an hour when it's time for dinner. She went in there. She was dead. I said, well, what happened? They called 911. They did the CPR, did everything they could. A perfectly healthy 16-year-old girl all of a sudden just died. And nobody knows why. Toxicology came back, didn't know. The school said nothing. They asked the school and said, well, we don't know. And did they really trust the school? Maybe it was just one of those flukes. Nobody knows. But why would something like that? So we would want to know everything about the child going on, because if it's my son or my daughter, I would really want to know. I don't hate my kids. I would want to know everything. And I'm sure that you would want to know what's going on with your son or your daughter. So I stand in support of this bill. Section F sort of concerns me a little bit. It says a reasonably prudent person. What is the definition of a reasonably prudent person? But it does have a couple of statutes in there that I have not read, so maybe it covers that. But say when it comes to mental health, as Ms. McCoy had mentioned with the gender identity and that sort of stuff, I think that's exceedingly important that parents know exactly what's going on.
30
Parents-
seconds.
And that parents need to be informed of what's going on and form a team of what's going on. I did have a daughter in Riverton High School that she had a problem with bullying. I talked to the counselor, we got with the other parents, solved the problem because we formed a team. Nothing was kept from anybody. So I appreciate it and I stand for questions.
Is there any questions for Steve? Thank you, sir, for coming. Representative Lawley, you're a lawyer. Would you tell us what reasonably prudent person is? It's a legal definition, as I remember.
Well, it is a term of art in the law, and it gives courts and/or juries the opportunity to determine in any given situation what they believe a reasonably prudent person would do. So it's a standard that there is some subjectivity to it, but the idea is that is determined by the court or a jury based on circumstances and what is common. It's just reasonably prudent that they would do that. So.
Does that help, Steve?
Yes, it is, sir. Thank you.
Great. Thank you. Thank you, Representative Lawley. Go ahead.
Hi, I'm Darcy Ostermiller. I'm a kindergarten teacher. I am here with Level Up. I just need some clarification. On Part C, when they talk about well-being questionnaires, with 5-year-olds, we have to question a lot. My biggest concern is when it comes to abuse. I do not ever want to put one of my students in harm's way. And by asking questions, would this restrict my ability to make sure they're safe? I guess my wonder is there something in this that needs to safeguard these kids in case of abuse?
Representative Lawley, please go ahead.
Thank you, Mr. Chairman. Thank you for being here. I didn't catch your name, I'm sorry.
I'm Darcy Ostermiller.
Well, thank you for being here. Could you give us some examples of how that works at that age? What kind of questions are you asking? That might help me understand better.
Well,
what you're
if you have bruising,
Please, through the chair.
oh, excuse me.
That's good. You're good.
Through Chairman Northrup to Representative Lawley. If a kid comes with a black eye, and then the next week they come with a bruise on their arm, time after time, you need to ask these questions. Well, you fell down the stairs. Well, some questions. Was there anybody around? Then if you have enough documentation, then you are a mandated reporter. Are we by law to contact the parents to say, I am turning this in to DFS? And what if they do not allow you to question? What if they say, you may not question my child about their well-being?
Representative Lawley? Okay. It's a good point. I grew up with brothers, and so I was beaten, battered all the time, and so were they, so. Yeah,
Well,
explains a lot.
Chairman, I hope that if a kid is abused, that we would be able to do something.
Thank you.
Lindsay Adam from Sublette County, teacher of 20 years and Level Up member. I just want to kind of address the elephant in the room. This bill has ramifications for nurses, for kindergarten teachers, things that happen on a normal day-to-day basis, interactions with students. You know, we constantly are checking in with our kids emotionally as well as academically. Academics are 40% of what I do.
Can I break in, please? Have you already testified?
Yes.
With your 3 minutes? Mr. Chairman, that opens it up to everybody to have a second bite of the apple.
Well, that's my call. Go ahead.
Okay, and I will split it up. besides all of the ramifications that maybe haven't been thought through for nurses, et cetera, this bill is really intended when I think about my middle school and high school students who are struggling with gender identity, who are struggling with sexual orientation. They seek an adult who they find is safe. It's often not teachers. Hopefully it's the school counselor, someone who's trained in that. My worry with this is that counselors have to break patient confidentiality and report to parents, well, your son disclosed to me that he's struggling with emotions and feelings about the same gender. If that child felt safe telling his parents those things, he would have. He is going somewhere that is safe because home is not a safe place for who he is. And it is a well-known fact that students that are struggling with sexual orientation are the highest risk for suicide. Nobody questions that. In fact, teachers are trained every year on how to help those students cope with that. And this flies in the face of that and makes me as a teacher feel like I have to report to parents when their children are struggling, and that's not my place in that situation. That's a choice between the child and their parent. And with that, I stand and yield for questions.
Go ahead, Representative Berger.
Thank you, Mr. Chairman. Thank you for, again, being here. Question to you and maybe all our teachers out there. The simple question, how was your weekend? How was your night? Is that going to be taken away from us? Should we, that's the question I have. And I don't see it in this bill, but I'm hopefully that isn't taken away because we get a lot of information there, not on purpose, but I just wondering, do you feel that?
Yes, Mr. Chairman, this bill does worry me because there are a lot of things my students disclose to me that I don't ask them to tell me. And because they have said these things to me, whether it's in front of a whole bunch of other students or just to me as they're walking out of the room, we are mandatory reporters if I feel like they're at safe for themselves, for self-harm or for hurting other students, I would report that. But I don't want to feel like I have to report everything. That's up to that child, especially if they're a high school and middle school student. They get to choose who knows their personal business. And it's often more people than should know their personal business, but that's their choice.
Go ahead, Representative Brown.
Thank you, Mr. Chairman. Let's take your scenario that you just said right there, that somebody has disclosed something to you you didn't ask them about. They just happened to say it in glancing past. The way that this very first paragraph reads is actually, I think, where most consternation is coming from is page 2, line 13 for everybody following along. It's by requiring school district personnel to encourage a student to discuss issues relating to his well-being with his parent or guardian, or to facilitate a discussion with the parent or guardian. As I read that, that would require you, every time something like that is said, if you feel like that's a concern, that would require you to tell them, you need to talk with your parents about this. Is that something that you already do, or is that something that you have personal discretion on when somebody tells you something?
Go ahead, Lindsay.
Mr. Chairman, Representative Brown, I would definitely say that's something I already do. If it seems like something that's really an issue, kids do 180s, something that's a major issue today is going to be something they've completely forgotten about next week. But the ones that are really struggling, because they start to have physical symptoms and then they're going to the nurse all the time. They're asking to see the counselor all the time. And I definitely encourage them, talk to your parent or do you have someone to talk to? Did you talk to the counselor yet? But I'm not going to tell their secrets to their parent.
Thank you, Lindsay.
Chairman, members of the committee, I'm Lisa Williams from Niobrara County. I'm neither in favor or against this bill, but something I just wanted to clarify or ask for question. I don't see anything about online education, and we have 3,000 students in the state of Wyoming currently being educated online. What accountability do I have as a principal as well as liability for parents' rights? I stand for questions.
Anybody have questions for Lisa Williams? Good point, thank you.
Thank you.
Anybody else like a second bite at the apple or the first one to start with? Here we go, Bill. Anybody else? All right.
Mr. Chairman, Bill Winnie, Sublette County. You had some things up here, like what do you do if a student comes in with a bloody nose, or you were lying on the field with a broken collarbone? My attitude is, you handle the thing, first aid, call it if you will, but you take care of that. The question gets into that this bill is trying to address is, what do you do when you get into keeping secrets from the parents? And you get into the issue of, who does the privacy actually attach to? And I believe if you get into the law, you're going to find in general, the privacy attaches to the family or the parents. And so how do we want school districts to handle this? Well, that's where DFS comes in. If you think there's abuse at home or whatever, you report it to DFS. They're the guys that should be able to handle that, as I see things. So again, I come back to, what kind of authorities do you want to grant a district? Subject to your questions. Thank you.
Thank you, Bill. Questions for Mr. Winnie? Thank you, sir. Please go ahead.
Good afternoon again, Chairman Northrop and members of the committee. I agree with everything that Mr. Winnie has just said. Why do we want to cut the parents out? If a child comes in and says, I'm struggling with this particular problem or that particular problem, I'm afraid to tell my parents. Well, I had a couple of car accidents when I was a kid, and I was afraid to tell my parents, but they found it anyway. They said, why didn't you just come to me? I wasn't going to do anything. And my daughter had a car accident. And the first thing she said, my dad's going to kill me. I go, why would you think that? Kids naturally think that, parents are going to come down hard because parents are disciplinarians. They're not their friends or their parents. And so if a kid comes in and says, please don't tell my parents, as a previous speaker had said, I think we really need to talk to your parents about this, but we can have a particular mediator in there, as Mr. Winnie said, DFS. To cut the parents out totally would be inadvisable, because then you're saying, we don't trust you. And I think that we need to make sure that, like the one speaker had said, well, if they keep on coming in with bruises all over the place and they weren't beat up by their brothers, then that would be a sign. But to cut the parents out totally, the parents would be utterly devastated. I have read so many reports across the country where parents were cut out and they were just utterly devastated. And they said, we could handle this. We want to help our kids. But the school is saying, well, we're making the decision for you. And that is completely wrong. I would stand for questions.
Representative Forenza has a question.
Thank you, Mr. Chairman. Have you ever had, when you were teaching, did you have students that were in foster care?
Please go ahead.
Chairman Northup, Representative Frenza, can't remember back that far.
Mr. Chairman, I assure that you did.
Okay.
And they ended up there because they were in homes that did not have their best interests at heart. Sometimes home is not safe.
Chairman
Thank you,
Northup,
Mr. Chairman.
Representative Frenza, most of the times, homes are safe. I think you're trying to make the exception the rule as far as the rule the exception, ma'am.
It's not up for debate. We're going to go on. Anybody else have a question?
Thank you, sir.
Thank you. Ms. Bradshaw, I'm not going to yield to you yet. Please go ahead.
Mr. Chairman and members of the committee, my name is Kara Hill, and I'm a 6th through 12th grade business teacher in Goshen County. My first year of teaching, I'm on year 12 currently, but my first year of teaching, I had a student approach me and reported to me that there was issues going on at home with sexual abuse. They were terrified because it was a stepfather figure in their life. For me, I would have a very difficult time having to report that to home because ultimately the student needs to have a place to live and food in their stomach. And yes, DSF was reported, everything was squared away, but to have to ultimately report that to the parents prior to that notification would put that student in greater harm. So I understand that there's a time and a place and that there are rules for a reason, and that the triad is a very powerful tool when implemented properly. But I also hope that we can take a step back and realize that in some cases, by following a bill such as this, it could ultimately be putting our students in further harm. So with that, I yield for any questions.
Does anybody have any questions for Ms. Kara Hill? Thank you.
Thank you.
Okay, go ahead, Representative Berger.
Thank you. Do you feel you keep secrets from parents?
When it's not a moment of time or safety issues, I feel like I'm a very open book. and I'm willing to communicate with parents for sure. But in the case such as my student my first year, who ultimately, thank the Lord, made it out and has a very successful life now, I feel in that case that is something that should be kept so that way it could be protection of the student, it's the person itself, themselves.
Further questions? Thank you, Ms. Hill.
Thank you.
All right, you both spoke before, so be quick about it, please.
I would like everyone to think about, after the last two here, again, where are the bounds of the school counselor, the school social worker, the school nurse, the principal, the teacher? We are mandated reporters, and we will report when it is necessary. I very much trust all of my 80 staff at the school of which I lead, that they come let me know, or a school counselor know if they feel something is going on. With that being said, it's not always the right thing to go directly to the parent. There is DFS for a reason. And then when it comes to that parent and student conversation, a counseling session, that is not what is within ASCA. So I think it's the American School Counseling Association. When you take a look at those, what ASCA school counselors should do and do not do, they are not in the private sector. That is family counseling, and that is not something that we do in the public school sector. So those conversations are needed. However, that is not within the school bounds. That's outside. And so our role as school educators are to let the right people know. So those counselors should social work outside DFS, whomever deem it fit to get the parent involved and have those conversations. That's where that leads. It's not with us. We don't do that in that school setting. That's all I wanted to say.
Clarification. Any questions for Ms. Bradshaw? All right, you can sneak away, yeah. Please go ahead.
Chairman Northrop, I just also want to offer a clarification. Ms. Janet Farmer, I'm sorry. I also want to offer a clarification. A previous testifier spoke about providing permissions and going through all the permissions done online. Usually, actually not usually, always, school districts have to get permission to provide medications to a student, whether they're over the counter or whether they're a prescription. Every school district in the state that I know of gets that permission from the parent, either through a paper permission form or through online. As far as I know, there are no districts in the state that require permissions to be provided from parents for services. So I don't believe that that is currently happening. That's the clarification I want to provide.
Any questions, Ms. Farmer? All right. There's nobody online? No. All right. Okay, we'll close public testimony. Committee, what's your pleasure on the bill?
Second.
Moved by Representative Lawley, seconded by Brown. How would you like to handle the motions? The emotions, yes. How would you like to handle motions?
Don't ask him. Don't ask him.
Okay, none on page one, I assume, so we'll move to page two. We're talking blue copy now. Everybody's
Chairman.
Go ahead, Representative Brown.
Mr. Chairman, I would move, follow me here, folks, page 2, line 12, after the word children, insert a period and strike the remainder of 13 through 16.
Been moved and seconded that we strike lines 13 through 16 on page 2.
Mr. Chairman, purpose for this, I think, is, I get where we're trying to go, and I think as a legislative body, we start encroaching on some serious potential pitfalls of this law if we put in there that we require school district personnel to encourage a student to discuss, but then if you go all the way back to subsection F, that you catch a school personnel individual in between requiring them to talk with their parents or determining whether or not that's a reasonably prudent personal thing to do. I think that is a big portion of what we've heard today of discussion of whether or not they are acting in the right ways. So that's why I'm making that motion, Mr. Chairman.
Thank you. Discussion on the motion. Representative Lawley. It was seconded by
Seconded.
Provenza.
Thank you, Mr. Chairman. I strongly oppose this amendment for several reasons. Number one, since the 1920s, the U.S. Constitution has ensured parents have the right to direct the raising of their children, including education. And I see this as kind of gutting in many ways the purpose of this bill, because the idea is to encourage them to talk to their parents, to encourage that interaction. It does not in any way conflict with the section F. In fact, the section F is something that we left in during the interim as we went through several iterations of this in order to provide the balance. It's not one or the other. They're not making a decision. This gives them this exception that also does exist in Supreme Court law, the only exception to parental rights, and it's here in the bill and it's protected there. So I feel the bill addresses these things. And again, I just am very much against the amendment.
So, Mr. Chairman.
Go ahead, Representative Brown.
So by understanding that, then it sounds to me like they're already covered. So reiterating this in the law is not necessary. It's
right.
reduplicating the exact same language that you're already espousing. Is that right?
Representative Lawley.
Well, no, I believe that the whole point of this particular bill is to help school districts navigate what it looks like to comply with the United States Supreme Court's decision that parents have a 14th Amendment constitutional right to direct the education of their children, direct the upbringing of their children. We're trying to help them understand what that looks like.
We have a motion on the floor. Any more discussion?
Question?
Okay, question being called. All those in favor of the motion to strike lines 13 through 16, page 2, please say aye.
Aye.
Those opposed?
No.
That sounds like it fails.
Show of hands, please. All those in favor, raise your hand. Okay, all those opposed? Okay, that motion has failed.
Okay.
Okay, page 3.
Mr. Chairman.
Go ahead, Representative Brown.
Mr. Chairman, page 3, lines 15, I would move to strike lines 15 through 21 through the term, or through the word services. So section B would start with parental or guardian consent to a healthcare service shall not waive the parental's rights or guardian's right to access a student's educational or healthcare, blah, 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 blah. I am striking what I am hearing, the largest portion of consternation on this bill is creating an all-encompassing list. Oh, wait, I'll wait for the motion. That's the motion.
Seconded by Representative Obermuller. Okay, go ahead, discussion.
Mr. Chairman, I think the term that really scares me is on line 18, and it says any healthcare services. The understanding from the school nurses, that just terrifies the living daylights out of me. As a husband of a school nurse, I can tell you, creating an all-exhaustive list of options and then to determine whether or not a nurse needs to go in and look at a computer to determine whether that parent has opted in or out of every single one of those when a student presents, I'm not okay with that. I do understand the portion of this bill that says, hey, look, we want our parents to have the rights to their student records, and that is kept intact. But I am striking the portion that says, hey, look, every school district is going to have to come up with a healthcare service offered list by everybody and present that, and every parent is going to have to opt in on all, or opt out of all those services.
More discussion. Representative Lawley, please go ahead.
Again, I oppose this amendment in first regard by what I already said about the last amendment, but also how many healthcare services are our schools offering? Okay, well, again, I didn't know that they, could offer that many, but either way, the parents have a right to know. Are you going to withdraw your previously written amendment on this section? I also wanted to know that.
I'll wait.
Okay.
Yeah.
All right. I'm opposed.
Representative Clausen, please go ahead.
Thank you, Mr. Chairman. As I read this, I'm not sure how specific this list needs to be. I read this as it could just be a list of nursing services provided under licensed nursing in Wyoming, licensed counseling services. I mean, no situation can take in every single healthcare thing that these nurses are going to see. It's going to change by setting. So I think that term could be a little bit more general. It's just the list would just be services provided by licensed nursing counselors, that kind of thing. I'm not sure that this says we have to list Band-Aids, you know, specific aspirin. I mean, I think, well, I think it's suggested, but I don't think it doesn't ask for an exact list of every single service provided, detail by detail. I think it could be more general.
Mr. Chairman.
Go ahead, Representative Brown.
Hey, with all due respect, the word, as I stated, is on line 18, and it says any healthcare services offered or provided at the student's school. I think that's pretty plain language that when we say the word any, and I have a secondary motion to back this up, but I think going into any healthcare services offered is an expansive list. I don't disagree. Somebody could read it that way, but I can also see it being interpreted as my school district didn't provide me every single thing that was offered, and therefore I'm aggrieved by this list, and I'm now going to take you to court. And that's what the next portion of this bill does, is it offers that grievance to be filed against them outside of the APA. I think striking this language, continuing to keep everything available to them, to the parents, I'm not striking anything about the parents having the availability to know this. But as we also heard, most districts are already offering these services to opt out of. What I'm concerned about is the all-expansive and all-inclusive list that it says any healthcare services.
Any more questions or comments? Anybody? All right, we'll proceed to vote. All those in favor of the motion of striking 18 through 21 on page 3, please say aye.
Aye.
Opposed?
No.
That motion's passed.
Mr. Chairman, I will
Representative
also
Brown.
move the amendment that you have listed here. Page 3, line 22, after the word service, so it'll read parental or guardian consent to a healthcare service. You would insert a comma, and the information here for the people out in the audience does not say, you guys don't have this, but it says including pain, injury, and illness assessments as defined by Board of Trustee rule and regulation. And I'll wait for a second on that.
It's been moved by Brown, seconded by Obermiller, that we have an amendment. Go ahead and. work your
Mr.
amendment.
Chairman, this just came as a discussion with Ms. Farmer and some of the other school nurses that I have talked with. Having some regulation underneath those particular areas of treatment, I think gives a little bit more guidance on the term of what a healthcare service actually is, and that provides a little bit more scope of understanding, as opposed to just leaving healthcare service. Again, that's a pretty broad term. So these are kind of artful terms, I believe, in the healthcare field as well. So that would be why I'm making this motion.
Further discussion on the motion, anybody? Not appearing, we'll proceed to vote. Oh, Lolly, would you have something? Okay. All those in favor of adding in the words, find them, including pain, injury, and illness assessment as defined by the Board of Trustees rule and regulation on page 3, line 22, after the word service, please say aye.
Aye.
Those opposed? That motion is also passed. All right, we're on page 4.
Mr. Chairman, last one, I promise.
Go ahead, Representative Brown.
Mr. Chairman, page 4, lines 9 and 11, or health screening, or information on the health screening, I would strike those. And then I'll wait for a second, and I'll explain.
Line 9 and what?
Line 9 and 11. So you have or health screening would be stricken. And then on line 11, or information on the health screening.
Second.
Moved by Brown, seconded by Provenza.
And Mr. Chairman,
Go ahead.
I could go either way with this one, but I do want to respect the fact that we do have health screenings. As I'm looking at this, it says before they're administering, they're just supposed to make this information available. I don't really have a problem with that, but I do believe that sometimes having that information, getting that information out there on a health screening, especially when it's vision screening, it's a hearing screening, scoliosis, those types of things, I don't know that that information actually makes it to the parents. And so my only concern is if it doesn't make it to the parents, then they're not covered by law. And so I get concerned about that. That would be my only reason for putting this out there.
Further discussion? Go ahead, Representative Lawley.
I'm against the amendment. It's simply asking the parents to be notified and get permission to have those assessments. And I think that, again, under the Supreme Court ruling, that the parents have the right to make these decisions. They can't make a decision they don't know about. Thanks.
Further discussion?
Mr. Chairman, I want to make sure that we're understanding this, and I respect the good lawyer here on the committee. This is good, because I do not see anything in this that says that they need to seek permission. This just says before administering it, the student needs to have the information available to them. There's nothing about permission being sought. So I just want to make sure I'm understanding that correctly.
Well, yes. in a
Representative
sense-
Lawley, please
Yep,
go ahead.
Sorry, Mr. Chairman. That's true. They don't have to give permission, but they have to be informed. And if they want to object, they have the opportunity to object.
Okay, that's good. Thank you, Mr. Chairman.
I would also add that those health screenings could be listed, because it's to the parent or guardian, so those health screenings could be listed on the webpage, and that they would be notified of when they are and what building they'll be in, and so
Yeah.
that would also be available.
Mr. Chairman.
Go ahead, Representative Obermiller.
Thank you, Mr. Chairman. So in this regard to notifying the parent and they object, is that the end of the screening then? They object and you can't do it. Is that right? So, Mr. Chairman, part of the testimony here today was that maybe the parent objects to the screening because they don't want them to know the underlying cause, and that the screening is critical to finding what the underlying cause might be, which might be the parent. So that's the issue here for me.
Mr. Chairman?
Go ahead, Representative Brown.
There's a good point to that being made, and then I sit there and I think about the term health screening. We just amended, my information as a service, but a screening could be encompassing of what we're talking about with K-3 reading assessments. Because dyslexia is a recognized, and do we honestly want to have parents the opportunity to opt out of the ability to determine whether or not their child is dyslexic because they don't understand what the terminology may mean, or chest auscultation because they don't know what that might be? I'm torn on this. Like I said, I could go either way, but I am torn on this particular amendment, Mr. Chairman.
Okay, any more discussion on it? Everybody's, all right, we're gonna proceed to vote. All those in favor of striking on line 9, page 4, or health screening 2, and then on line 11, page 4, or information on the health screening. All those in favor of striking that, please say aye.
Aye.
Those opposed, please say aye or nay.
No.
Thank you. Nay, no is correct. I'm gonna do it by a show of hands. All those in favor signify by raising your hands. Okay, all those opposed? That motion's passed. We've stricken that language
Mr. Chairman, I'll shut up.
for the time being.
Well said, Mr.
Anything on page 5? Anything on page 5? We'll move on to page 6. And lastly, page 7. And page 8. Anybody? Any questions, comments on the bill? Go ahead, Representative Provenza.
Thank you, Mr. Chairman. When we talk about parental rights, it's often posed as the government and parents, and we miss out on the concerns of children. And I can't help but think back to when I was a child myself and my family provided foster care. So we had foster kids in our house. And those kids would come to us sometimes with cigarette burns on their bodies, bruises, bite marks. We had one kid that I remember very well. When we were driving home, we went over some bumps in a vehicle, and he thought that the truck made those feelings happen. He didn't understand roads. These were kids that came, had never eaten meat before. They didn't own underwear. They were severely neglected. They were abused. And I think about those kids being in a school, and I wonder, what about them? What about their rights? Am I going to force teachers to go talk to parents that burn their children with cigarettes? And over what? We already have in our Constitution parental rights. We have a court that is hearing a case right now, and they have not finished that case. No one has said that the school district did harm. But we want to bring legislation to say that we should strip the rights of children away. This is a harmful bill. This conversation continues to be harmful. We continue to erase children. And I hope that you will vote no with me.
Further comments by the committee? All right, we'll call the question on the bill and go to voting. Ashley, would you please call the roll?
Mr. Chairman, on Senate File 9, Parental Rights in Education 1 engrossed do pass as with amendments. Representative Allred. Representative Andrew. Representative Berger.
Aye.
Representative Brown. Representative Klauston.
Aye.
Representative Lawley.
Aye.
Representative Obermueller.
No.
Representative Provenza.
No.
Chairman Northrup. You have 6 aye and 3 no.
Thank you, Ashley. We are adjourned.